Hello, and welcome to the Health Go Live webinar series. Today's episode is brought to you by our friends at Ropes and Gray. We would like to remind you that the Q&A feature is available, so feel free to send in your questions and comments throughout today's webinar. We would love to hear from you. And with that, I will turn it over to our speakers.
Hello, thank you everyone for joining today. My name is Christine Moundis. I'm a partner in the healthcare group at Ropes and Gray. I also participate in our data practice and I co-lead our digital health initiative. I'm joined here by my colleague, Jen.
Hi, I'm Jen Romig. I'm also a healthcare partner at Ropes and Gray. I work out of our Chicago office, and I do quite a bit of work around data and data privacy and transactions and counseling work. And I'll turn it over to David.
I am David Peliquin. I'm a partner in the Boston office of Ropes and Gray. I'm part of the healthcare group as well. I counsel a lot of entities that participate in clinical research on both regulatory issues that arise in research and data privacy implications, both in the transaction and counseling context. Nice to be with you all today.
Today, we're going to try to talk through all things data privacy in the healthcare and life sciences space, and in particular, the way new and emerging laws and guidance are changing the landscape for our clients. So I'm first going to talk a little bit about the new state consumer privacy laws, as well as the state health laws, and what that has meant for our clients in terms of needing to really reinvent their compliance programs in the area of data privacy and security. We're then going to turn over to Jen. She's going to talk a bit about FTC developments and other data enforcement related updates. And then at the end, David's going to talk about some of the international data transfer issues that are really evolving tremendously under the Biden administration and likely the Trump administration. So with that, I think we can dive in. What we're going to do is try to talk through these issues one at a time. Feel free to put questions in the chat if you have questions for us, and we will try to answer them as we can during our presentation. And at the end, we're also going to, Jen's right here with me, David too, will try to be a little interactive in this, given that we're all advising clients in this space. And there's definitely a lot of differing perspectives that we all have to offer, given that this is all very, very new. So just to set the stage, the US data privacy law landscape has completely evolved over the past 5 years. It's really essentially like advising in completely new territory. We are now moving to a construct, at least on a state-by-state basis, that is more GDPR-like than we've ever seen before in this country. Of course, all of us know this was really first spearheaded by California. And in 2009, with their passing of the California Consumer Protection Act, which was later amended, so CCPA as amended by CPRA, that really set the stage for states realizing, if there's not going to be a federal solution to data regulation, then the states have to step in and fill the gap. So we are now in the midst of a giant wave of state legislative activity and regulatory activity. And I would say it's a full-time job just keeping up with these developments. Currently, if we're talking about statewide consumer-focused general privacy laws, there's roughly 20 states that now have laws passed, and roughly half of those are already in effect. A few years ago when CCPA was out front and we were mainly worried about California, companies were really trying to reinvent their data privacy programs in a way to specifically address California's requirements. But now, as a few years have passed, and with every year, new states are piling on with slightly different frameworks, we're all trying to work with our clients to make sure that they actually have a more flexible approach to these data privacy requirements in order to be able to have more of a nationwide approach instead of having a bespoke way to address each state separately. So I think, a few years ago, we were doing CCPA compliance programs, and now we're really trying to really broaden it so that companies don't have to constantly be revisiting and revising their website terms, their privacy policies, their general mechanisms of providing privacy rights. So again, 20 laws over the past few years out of nowhere. It's really tremendous. In addition to the general consumer-oriented privacy laws, which have an impact on healthcare and life sciences companies. There's also health-specific privacy laws that are consumer-oriented, and those are really intended to fill the gap. We primarily are thinking about Washington with the Washington My Health, My Data Act, as well as Nevada and others. With this additional overlay, it actually causes a real host of complexities for companies as you're trying to meet all the consumer privacy laws, determine which ones actually apply, and then layer on even more restrictive health-oriented consumer laws. So when thinking about all of this, really, I try to tell my clients we have to try to not make perfect the enemy of good, and try to put together a reasonable compliance program that's going to meet as many of these requirements as possible. And I will just say, this is a very, it's a tough task. Because even when we're talking about privacy policies, privacy notices, the regulators are saying you have to be very clear and concise so that people actually know what you mean. And then simultaneously, they're piling on 20 different requirements that are actually very burdensome to meet. So there's these very, I'd say, competing directives that companies really now need to face. So just to zoom out in terms of how should companies approach these laws, and what are these laws trying to accomplish? Essentially, these laws are trying to ensure that companies are actually processing personal information of consumers in a way that allows for sort of the minimum necessary information to be collected, that it's being collected for reasons that people would reasonably anticipate, and that's actually tied to the way they do business with that company, to ensure that data is actually protected in a way that's appropriate, instead of there being a free-for-all of, additional data flows that might not be appropriate or anticipated, as well as ensuring that there's cybersecurity controls and accountability around that data, as well as having patients be able to actually assert rights over the data. And that's both in terms of what's initially collected and them having, upon collection, notice of what's going to happen with their data and what's being collected, and why, as well as them knowing where their data is going and for what purpose. And then to be able to have their data deleted or modified, or get copies of it, as well as other privacy rights. And all these things are really new constructs in the United States, but obviously we know there's been plenty of data-related sagas in this country over the past several years that have put really a spotlight on ensuring that the business community treats people's personal information appropriately. So really, a lot of my clients, some of them, right, you have some really big companies that this task of compliance is difficult because the companies are so complex. It's very hard to meet all these requirements. And then you have other companies that are smaller, and the task is very difficult because not necessarily that their operations are overly complex, but this is a lot of compliance overhang to put on smaller companies. So I try to break it down for my clients in terms of where to start. What's the appropriate thing to sort of focus on first and foremost? So I think first, I like to tell my clients, it's really important to try to analyze these laws and figure out what they mean for your company, because many might mean nothing for you and some might mean a lot for your company. So first and foremost, it's important to look at these laws to see a lot of them have exemptions for not-for-profit entities. And because of that, a lot of not-for-profit health systems, universities, others are not subject to many of these laws. That's the first thing to look at. But obviously, for-profit pharma companies, biotech, med device, they are very squarely in scope. Others have different revenue thresholds under these laws. And it's important to figure out what the revenue thresholds are under these different laws and how would they actually apply to your company. And also anticipate, if the revenue is not meeting the thresholds this year, but they will next year, starting to anticipate that and building towards compliance, given that compliance usually takes a period of time. Then it's important to understand what types of data are regulated, or if there's really individual personal data thresholds that might be relevant to your company. Some of these laws only apply if the company processes let's say 50,000 people's personal information from a particular state. And depending on how regional your business is, or just what the overall statistics are for the amount of personal information you're getting in different states, you might not actually be subject to the laws. And then other thresholds relate to amount of data sales that can be attributed, to data transactions. So looking at those and seeing if those data revenue thresholds are relevant is also important. So I would say doing that assessment at least every 6 months is very important. And to the extent you can actually document in a file internally within legal or compliance, et cetera, that you looked at all these laws and that at a point in time, January 2025 is coming up. So it's a good time, fresh new year, to look at all these laws and actually determine what applies and what doesn't. And I think that's your starting place. And I would recommend sort of making that version 1 of the memo whenever you do that, and then versioning up every 6 months, adding new laws that come online, checking the old ones, and seeing if the analysis shifts at all. I think that's a very protective measure that companies can do to show that you have an awareness, that you've actually tried to apply these laws to your business, and that you have a reasonable basis for determining whether you're in or out of scope. Once you do that, then you can identify what are the laws that actually are going to apply to your company. And obviously, if only 3 out of 20 apply, I think it's very reasonable to only hit the requirements for those 3 laws. If you're in for all of them, then you have to try to have some reasonable approach to how you're going to meet all these disparate laws. All of these, across the board, almost all these laws require very clear disclosures of all the different types of data that the company collects and processes or otherwise transacts, and for which types of sort of relationships this relates to. So this means, is this employee data? Is it consumer data? Is it business partner data? There's all different categories, and they really require some level of data mapping to say, what are the sort of types of business relationships that you have? What are the categories of personal information that you hold? And then when are you collecting them and why? For what purpose, and when do you disclose that data? And that essentially requires a data mapping exercise. And I would say the data mapping is a very tricky area because it could be extremely burdensome, but at least try to get some reasonable starting place for what are the main categories of individuals, data subjects that you have the data for, and what are the main categories is really important. This is, again, in order to not make perfect the enemy of good, trying to have, list broad categories that tee to the regulatory requirements, and using language such as including but not limited to is really key. Then you have to actually put these categories and the uses and disclosures into privacy notices. Previously, as you all know, companies used to have website privacy policies that really spoke to just data collection through websites and mobile apps. These new state laws are really setting a requirement for public statements of how the company as a whole processes information. So now website privacy policies are sort of serving a dual purpose of being not just about the website, but actually being the public facing statement of the company of how it processes data and why, et cetera. So now there's really so much more emphasis on carefully drafting these public privacy policies and having them serve in some cases as privacy notices themselves. We'll also note that the regulators are very quick to jump on any divergences between your practices and your public statements on what you do. So many of the settlements that we've seen from AGs or the FTC, et cetera, they actually look at your public statements on your practices, and then they hone right in on any place where you've given assurances that something would or wouldn't happen, and if it happened to the contrary, to point that out. In terms of other activities, besides the determining applicability, the data mapping, and then the actual drafting of your privacy policies and privacy notices that are external, there's also a host of other activities that are required. Many of these laws actually require companies to ensure that there's actually data protection agreements or other sorts of contracts in place with vendors to ensure that the vendors are safeguarding data in accordance with law, as well as processing the data only in accordance with what the business, relationship would allow, as well as honoring data subjects' rights if the primary company needs to rely on that vendor to effectuate the rights. Other activities that are required, we're going to talk about it a little bit more, but obviously online collection of data in an automated way through online tracking tools has now created a real landmine, and providing website cookie management, cookie banner notices, and enabling the technology to manage those tools is key, because that sort of serves as an automated way of data collection that might not be anticipated, and which has led to a lot of regulatory activity and litigation that Jen's going to talk a little bit more about. There's also just having the availability of creating the pathways for data subjects to actually effectuate their privacy rights or make requests related to their privacy rights, for folks to talk about how they might need to restrict their collection of sensitive information or the further disclosure of the sensitive information, to have really a public-facing, part of the company, which will actually now process all these rights that did not exist previously. We also then, obviously, if all of this has to happen externally, there's so many things that have to happen on the back end to enable all of this. So we help our clients, develop internal policies that will actually support all of these processes that I'm talking about. There's also training that's required. And then there's just various, oversight to ensure that the company is actually acting in accordance with all of these requirements. So I think with that, that gives a very high level overview of the way we approach many of these requirements, and a little bit of the practical advice about how we're trying to assist our clients in tackling them. With that, I'm going to turn it over to Jen to talk about the next topic. We're actually I'm gonna switch seats with her, and she will take it from here.
Thank you, Christine, and thank you for sharing your office and camera when my tech is down. Some things never change, even if the privacy laws do. So I'm going to talk a little bit about recent FTC enforcement actions and where we might see the FTC go next. So, at the outset, I first want to acknowledge that the FTC priorities we're going to talk about now may shift with the incoming Trump administration, and it's difficult to say exactly how that will change. However, we have heard some people say, well, there really won't be much in terms of privacy or security enforcement or consumer health data enforcement under the Trump administration. And that certainly wasn't the case in the past. In 2019, for example, the FTC still had big enforcement actions in the area of consumer health privacy. They announced at the time a record-breaking settlement against Facebook for violating consumer privacy and deceiving users about the ability to control the privacy of their personal information. The FTC in that time period also settled with Google and with YouTube over alleged Children's Online Privacy Protection Act violations. And at the time, Google and YouTube paid a record $170 million to settle allegations that they had illegally collected personal information of individuals without their parents' consent. So certainly we still see, even under the first Trump administration, FTC taking actions in the space of consumer privacy. We think that will continue to occur. But that said, in the last few years, we've really seen an almost unprecedented level of FTC enforcement around privacy and security of consumer health information in particular. And so what we're looking for in the upcoming years is to see, first, does the upcoming administration have the same level of robustness when it comes to enforcement of consumer health privacy rights? We're also looking to see, where are FTC priorities? Are they going to be consistent with recent FTC actions, which have been very focused and very targeted? So let's talk a little bit about the recent FTC enforcement actions in the past 2 years, and how the FTC is sort of bringing these complaints against healthcare companies. So first, the FTC often brings allegations against companies under Section 5 of the FTC Act, alleging that a company engaged in unfair or deceptive acts or practices. Christine referenced this a bit in her discussion of the state laws and mentioned that it's very important to keep your privacy policy and other publicly available documentation about the privacy and security of health information up to date in order to avoid any issues under state laws and any allegations that you've misrepresented your privacy or security claims. The same is very much true from an FTC perspective. When you look at FTC actions over the past few years, we can see that the FTC hones in on privacy policies that are promulgated online, as well as claims that companies make to consumers about the privacy and security of their information. And so it's not just the privacy policy itself that is important to review, and it's also the website terms of use. And it's also any other claims made in marketing or on your website about the privacy and security of health information. A second avenue that we've seen FTC bringing enforcement actions under is actually the health breach notification rule. So the health breach notification rule has gotten a lot of press in recent years. It was originally enacted in 2009. And I think for about a decade, no one thought about it much. There were no enforcement actions associated with the HBNR. The HBNR requires vendors of personal health records and related entities not covered by HIPAA to notify individuals, the FTC, and in some cases, the media, of a breach of unsecured, personally identifiable health data. And it also requires third-party service providers to vendors of personal health records and what are known as personal health record related entities to notify vendors and notify PHR related entities following the discovery of a breach. And so this rule was promulgated but sat stagnant for a while, and I think it was interpreted fairly widely as a relatively limited rule. It wasn't really, we didn't see or hear of many breaches being reported consistent with the HBNR, and the FTC hadn't taken any enforcement actions under the HBNR. In 2021, the FTC issued a policy statement clarifying that the HBNR applied to health apps and other connected devices. This was a clear warning, and to many people, it was also a big surprise. The interpretation of personal health records, colloquially, had often been of a fairly limited type of entity. Maybe someone who is actually, akin to an EMR, but for individuals. And the FTC's policy document made clear that a personal health record could be something like a mobile app, where the individual user inputs information, and so does, for example, a device. And so that caused a number of organizations, particularly mobile health app organizations and others not covered by HIPAA, to reevaluate their own privacy policies and practices. The FTC did begin enforcing and brought enforcement actions related to the HBNR beginning in 2023. So let's talk about a few of those enforcement actions and what takeaways we can learn from those. So in 2023, the FTC started really with a bang in the beginning of the year in a first of its kind enforcement action alleging that GoodRx, a telehealth and prescription drug discount provider, violated multiple laws, including the HBNR, by sharing sensitive customer information with Facebook, Google, and other advertising platforms without its users' knowledge or consent. So this was the first action under the HBNR. And as part of it, GoodRx was required to pay a $1.5 million civil penalty for its alleged failure to comply with the HBNR. And the FTC secured strong injunctive relief. And this really distinguishes the FTC from certain other agencies. For example, OCR in its settlement agreements and orders often doesn't secure as strong injunctive relief as the FTC is able to do. Here, the FTC required GoodRx to institute a comprehensive privacy program, notify consumers that it had improperly disclosed their health information, instruct third parties to delete the health information disclosed to them, and disallowed GoodRx from conducting similar practices in the future. Following on the heels of GoodRx, FTC also filed a complaint against BetterHelp and online counseling services, similarly alleging that BetterHelp had shared sensitive mental health data with Facebook and other third parties for advertising purposes without consumer consent. This was notable because the FTC obtained an order banning BetterHelp from sharing sensitive health data and requiring it to pay $7.8 million to provide partial refunds to customers. And throughout 2023, we saw similar actions and similar enforcement actions out of the FTC, including against Premom, which is a period and ovulation tracker mobile app, as well as against Flow Health, the developer of a period and fertility tracking app. And we see a few trends throughout the 2023 and heading into 2024 enforcement actions out of FTC. First, FTC focuses on highly sensitive health data. So when you take a look at BetterHelp, it's an online counseling service. It collects mental health data. When you consider GoodRx, it collects information related to individuals' health conditions and their medication usage. When you look at Premom and Flow Health, they collect information related to an individual's, period, fertility tracking, ovulation tracking, reproductive health related information, which has become highly sensitive information in the wake of Dobbs. And the FTC continued that trend into 2024. It had two big settlements earlier this year, one with Monument and one with a company called Cerebral. Monument also collected very sensitive data. They assist individuals with alcohol treatment. And Cerebral also collects mental health condition related information as well as pharmaceutical information. And in both of these cases, FTC alleged that Monument and Cerebral had made promises to consumers about how they would treat their health information and their health data, that they would keep it private, that they would keep it confidential, that they would only use it for the benefit of the consumers. And instead, what Monument and Cerebral had done was to use this information for their own benefit instead. And as part of that, and in doing that, the FTC found that they had violated Section 5 of the FTC Act in terms of making promises to consumers and failing to live up to them. Now, we've had one interesting question, which I want to address here, which is a question about how does the FTC rule impact healthcare provider websites? And are healthcare providers facing the same scrutiny? It's a really interesting question. So healthcare providers are typically governed by HIPAA, including potentially the information collected on their websites. That has been a subject of some controversy over the past year, as far as concerns things like online tracking technologies and the information collected there. Typically, healthcare providers fall more under the ambit of OCR or some of the state attorney generals than the FTC. Now, I do say typically there because the FTC, in the wake of Monument and Cerebral, has made clear, and I think their tagline is FTC and HHS joined at the HIPAA, which FTC likes to give these funny plays on some of their guidance. But what they say is that the Department of Health and Human Services is charged with enforcing HIPAA and the HIPAA rules. However, if companies make allegations or make promises to consumers that they are HIPAA compliant and protect information in accordance with HIPAA, and they fail to do so, in those cases, the FTC has brought cases alleging that those companies used words or seals to falsely claim HIPAA compliance. And this was actually the case for Monument and for Cerebral. Both of those companies are actually need to comply with HIPAA and reported HIPAA breaches the year before for uses of online tracking technologies. Now, I do think when looking at a typical provider website versus companies like Monument and Cerebral, one thing that really distinguishes where the FTC often chooses to leverage its enforcement efforts is the kind of company it is and whether or not the company is making services available for purchase by a consumer. And so, for example, FTC enforcement actions have not been focused on large hospital associations or providers who receive, reimbursement from health plans. That just hasn't been where the focus is. Instead, a company like Monument, a company like Cerebral actually charged a monthly subscription fee to consumers in order to belong and to use the company's services. So I think that sort of that is worth a consideration. If you are a provider-related service, and you are actually charging some sort of a monthly fee using an app, growing very rapidly, it is absolutely something that could come under the purview of the FTC if strong promises are made to individuals about privacy and security of health information that are failed to live up to in the FTC's eyes. However, we don't typically see that focus from the FTC because most provider sites are not actually charging sort of monthly subscription or monthly services to individuals. Now, I want to talk a little bit about takeaways here from the FTC. And I really want to put in a plug for FTC guidance. Unlike many federal agencies, FTC makes its guidance readily available and easily digestible. That's part of their intention for consumers. They are really not trying to hide the ball. They want everyone to know about what you should be doing as far as your websites, your apps, and your treatments of consumer data and consumer health data. So what we can learn from these enforcement cases and some guidance and lessons that the FTC has mentioned. First, the FTC cautions businesses to avoid making deceptive HIPAA-related claims and to avoid deceptive HIPAA seals and certifications. This is difficult because we find often that companies are proud of their privacy programs and their security programs. They know that individuals are nervous about providing their health information and health data, and companies do want to make promises to those consumers about how the companies will use and disclose their health data. However, what the FTC tells us is that you need to be very, very careful about making those promises, and you need to make sure that you can back up those promises with your actions. Because if you promise a consumer something, especially if you use strong language or representations, and you can't substantiate that, that is something that can be held against you at a later date by the FTC, also, as Christine alluded to, by state AGs or in class actions or other private litigation. A second takeaway from FTC is that, many of the companies who started out with mobile apps and many of the companies I just mentioned consider themselves software companies operating in the healthcare space. But those companies, given the amount of sensitive health data that they consume, really need to view themselves as sitting in the healthcare space. When you're in the healthcare sector, you need to make health privacy and security part of your corporate DNA, as the FTC refers to it. And so if you collect sensitive health information, or if you use sensitive health information from an FTC perspective, you've upped your compliance ante, and you need to be thinking about privacy and security protections on the front end, including in the fundamental design of your websites and apps. Another piece of guidance which comes from some of our work with clients is that often if clients do consider privacy and security on the front end of those apps, sometimes they let others manage the website or apps as time goes on. And so, for example, if your marketing team is allowed to help manage your website without oversight from legal, even if you've built in good privacy and security protections, those protections may be eroded over time. And finally, one of the last things I'll mention as far as the FTC guidance goes is, the FTC has had a focus on, again, some of these mobile applications, subscription-based applications. Another thing that's gotten hooked into these privacy and security enforcement factors is not giving consumers the easily and clearly available way to sort of cancel those services and to make clear about what happens with their data following cancellation. So that's another thing to keep in mind if that's the type of model that you're looking at. And I'll answer one more question here that we had in, which was around, if Cerebral and Monument were found to violate the law due to using the data to serve themselves, what does that look like? What does that type of data look like versus using the data to improve the effectiveness of their product or service for their consumers? Here, Monument, Cerebral, and many of the others that I mentioned were actually taking their consumer health data, providing it to Google, to Facebook, to others through the use of cookies and other tracking technologies on their website. And then they were allowing, in many cases, Google, Facebook, the other tracking tech companies to use that data in order to retarget the individual users to advertise to them for different products, different services. And that was advertising to them both for example, Cerebral, but also potentially for other related services that Facebook or Google had identified that the user might be interested in. So if you're a user who's given very sensitive mental health information to Cerebral, particularly around a certain diagnosis state, imagine if that information was later used to target you for other services that you might want to purchase related to your particular diagnosis. And so that was part of what was using the information provided by consumers. It wasn't in a way that was designed to improve the services of Cerebral or anything like that. It really was designed to sell more services to those customers based on their diagnosis and information. And so I know we have a few more questions in here, but I think we're at a point where I am going to turn it over to David to talk a little bit. David, if you're...
Yeah, thank you, Jen. So Christine and Jen have given you all a nice overview of recent developments related to health data in the US. The requirements that they've spoken about that are largely enforced by OCR, FTC, and state attorneys general are largely focused on the protection of individuals' privacy and their role as patients and consumers. I'm now going to talk a little bit about some recent developments in the United States in the past year that either restrict or propose to place restrictions on the cross-border transfer of personal data. I think that these are noteworthy developments for two reasons. First, they would represent the first time that the United States is restricting the cross-border transfer of personal data outside of the US. And while we're used to seeing foreign countries like the EU and the UK with GDPR and China with the PIPL placing restrictions on the transfer of personal data across international borders, this would be something new for the United States to pursue. And second, in thinking about these restrictions, I think what's notable is that they are grounded largely in national security as opposed to protecting personal privacy interests. And thus they're focused on restricting flows of data to countries that the US finds to pose a national security threat to the United States and its residents. And this is quite a bit of a different rationale for cross-border restrictions than what we find in, say, GDPR, where one is focused on protecting an individual's personal right to privacy under EU law, and thus restricting cross-border data flows to ensure that data of Europeans is protected. The focus in the US on national security, I think, is helpful to keep in mind in understanding the government's rationale for these new proposed restrictions and in formulating comments if you're going to comment on the ongoing rulemaking process. So I'm going to focus briefly today on three developments. One is the Biden administration's executive order from February of this year on preventing access to Americans' bulk sensitive personal data and US government-related data by countries of concern. I'm going to talk briefly about the Protecting Americans' Data from Foreign Adversaries Act, which is now law. It was passed by Congress with broad bipartisan support in April and took effect in June. And I'll also briefly mention the Biosecure Act, which passed the House of Representatives in September and is now pending consideration in the Senate. Now, many of you may think, are these initiatives, are they going to go away in the Trump administration? I think an important thing to keep in mind is the concerns about China and other countries of concern are one of the few areas of bipartisan agreement. And so while there might be some modifications to the policy, I think they're going to see a trend under the Trump administration as well on having more restrictions on dealings with China and other countries of concern. So as I'd mentioned earlier this year, on February 28th, President Biden issued this executive order on preventing access to Americans' bulk sensitive personal data and US government-related data by countries of concern. And in issuing this executive order, the president invoked his authority under several national security-related statutes. The executive order did a number of things, but most notably, and what I'll focus on today, is it directed the Department of Justice, or DOJ, to promulgate regulations that restrict or prohibit certain transactions that involve bulk sensitive personal data of US persons or US government-related data in certain countries of concern and covered persons. This rulemaking process moved quite quickly because on the same day the executive order came out, the DOJ issued an advance notice of proposed rulemaking on which comments were due in April. And the DOJ followed that with a notice of proposed rulemaking in which they did consider a number of the comments that were submitted back in April. This notice of proposed rulemaking issued on October 29th, and comments are due next week on November 29th. What does this notice of proposed rulemaking do? Well, it generally provides that except as otherwise authorized in the regs, no US person, so that would be a US resident, US citizen, or US company, on or after the effective date may knowingly engage in a covered data transaction with a covered country of concern or a covered person. So lots of terms of art in there. Who are these countries of concern? Who are covered persons? What types of transactions are limited? So the notice of proposed rulemaking defines the countries of concern to include the People's Republic of China, which I'll call the PRC for short, and that expressly includes Hong Kong and Macau. And it also includes Russia, Iran, North Korea, Cuba, and Venezuela. And the law also applies not only to the governments of these countries, so it's not only doing business with these governments that could be problematic, but it also applies to covered persons, which would include foreign persons primarily resident in countries of concern or foreign entities organized under the laws of a country of concern or having their principal place of business in a country of concern, and a few other types of covered persons enumerated in the proposed regulation. The types of transactions that are proposed to be restrictions are divided into two types. There's prohibited transactions, which by their name would be prohibited in all circumstances they couldn't take place. And those would include certain data brokerage transactions where one might be licensing data to a third party who didn't collect that data. And then maybe most notably in the healthcare sector, included in prohibited transactions are transactions involving bulk genomic data of humans or human biospecimens from which bulk genomic data could be derived. Restricted transactions are those which could still take place, assuming that this rule is finalized in its current form, but they would be subject to certain security restrictions specified in the rule. And that includes certain types of vendor agreements, employment agreements, and investment agreements to the extent that agreements provide access to bulk sensitive data of US individuals. And what do we mean by bulk US sensitive personal data, the types of data that would be restricted here? Well, it's data of US individuals. So we're talking about US persons here. So if you're holding data of Europeans, that actually wouldn't be picked up by these restrictions. But the types of data at issue are US personal data, like covered personal identifiers, like social security numbers or driver's license numbers, personal financial data, personal health data, which has the definition of individually identifiable health information under HIPAA, but applies regardless of whether the data originates at a covered entity or business associate, geolocation data, biometric data, human genomic data, in combinations of these categories. Now, I've used this word bulk a few times because the proposed regulation restricts the bulk transfer of data. What is bulk? Well, it depends on the type of data we're talking about. The proposed rule says it could be as much as 100,000 US persons for certain personal identifiers and as low as 100 US persons for genomic data or biospecimen. So if you think about that for a second, you have a transaction in the life sciences space where you're providing 100 biospecimens of US persons or 100 US persons genomic data to an entity in the PRC, that would become a prohibited transaction under this proposed regulation, which could be quite significant for the life sciences industry. What's also notable here is that the NPRM, like the advance notice of proposed rulemaking, state that there is no exemption for de-identified or anonymized data. And that's really worth pausing on for a second, because even under other strict privacy regimes like GDPR, we always see some type of exception for anonymized data. Now, it might be hard to make data anonymized under GDPR, but there is an exception there. Here, the DOJ is saying we're so concerned about national security and the sharing of, let's say, genomic data with the PRC, we're not going to have any exception for anonymized data. Although that's something they've sought comment on because this is a proposed rule. That's one of the questions they've asked in the rulemaking for people to comment on. There are some proposed exceptions in the notice of proposed rulemaking, many of which I think were made in response to comments on the advance notice of proposed rulemaking, which is just a plug that comments can be helpful. If you submit comments, they are listened to sometimes and responded to. And so some of the exceptions we see in the proposed rule are for official business of the US government, which would apply to US government funded activities, like if you're doing research under an NIH grant. There's an exception for drug, biological product, and medical device authorizations, which I think is intended to allow US companies to submit data to, for example, the China FDA in support of a marketing authorization. But if you read the rule, that exception is actually fairly narrowly tailored, and it's something on which the department has sought further comment. And there's also a proposed exception for clinical investigations, like clinical trials, that are subject to the FDA regulations on clinical trials, or that for the data from which will be used in support of an FDA application in the future, and some exception for post-marketing surveillance data. But if you read the rule, they're pretty narrowly constructed, and it's something on which the department has sought comment. One other thing I will note is that the DOJ regulations have this broad carve out for US government funded activities, but the executive order that Biden issued in February calls for other executive departments and agencies like HHS, the VA, the DoD to issue their own regulations or guidance restricting flows of data in their funded activities to the PRC and other countries of concern. So if you're a university, for example, that engages in a lot of federally funded research, you'll want to watch out for parallel rulemaking processes or guidance from the funding agencies. And as I mentioned, comments on this DOJ rulemaking proposed rule are due on November 29th. So if you're interested in making comments, you need to move quickly at this point. One of the other things I wanted to touch on briefly is the Protecting Americans' Data from Foreign Adversaries Act. This was signed into law back on April 24th. It was part of the sweeping foreign aid bill, which also included the well-publicized TikTok ban. And the law took effect on June 23rd. And what the PADFA, as I'll abbreviate it, does is make it unlawful for a data broker to sell, license, rent, trade, transfer, or otherwise make available personally identifiable sensitive data of a US individual to the PRC or certain other countries of concern, i.e. Russia, North Korea, and Iran, or to entities that are controlled by those countries. And data brokers are entities that, for valuable consideration, make available data of US individuals that the entity did not collect directly from such individuals to another entity that's not acting as their service provider. There's certain exceptions in PADFA, unlike the executive order and DOJ rulemaking. There's some exceptions for if you're transmitting data at the request of an individual, if you're providing a product or service to the PRC or one of these other foreign adversaries, and the data is not actually the product or service being provided. There's an exception for certain journalistic and news activities, and also for service providers. The types of data that are covered here include sensitive data like health data, biometric data, genetic data, race, ethnicity, a fairly broad swath of what we might consider sensitive data. But notably, PADFA, unlike the DOJ rulemaking I talked about, it does require that the data be individually identifiable. And so de-identified or anonymized data would likely fall outside the scope of the act. And this law is enforced by the Federal Trade Commission. And as Jen said earlier, the FTC tends to issue a lot of helpful guidance. They haven't issued any guidance at this point on this, but they may do so. They're not required to do so by statute. And so something to watch here are your flows of data to the PRC and other countries of concern, and thinking about whether you might be implicated as a data broker. And I realize we're coming to the close of our time. The last thing I'll say that you'll want to watch out for is there's also the Biosecure Act, which is still pending in Congress. The House of Representatives passed the act in September of this year. It has not been passed by the Senate yet. There's broad bipartisan support for that bill, though, however. And the current draft of that law prohibits executive agencies of the US government from entering into certain contracts to obtain biotechnology equipment or services from certain listed companies like WuXi and BGI, MGI, and Complete Genomics, or their subsidiaries or affiliates. And it also prohibits the US government from contracting with entities that, in their performance of that federal government contract or in the performance of a grant from the federal government, are using services of one of those companies. So it's not directly data related, but in conversations about restrictions on data flows to the PRC, it's coming up a lot with our clients. And so if you have arrangements with those listed companies, you're going to want to analyze carefully what exactly the services being provided are, and if there's any nexus to government contracts or grants that your company is performing. So with that, I'm going to pause, and I think we have some time for questions. And I saw there was a question about international transfers, a little bit different than what I was speaking about, but there was a question about the EU-US data privacy framework, which of course is one of the mechanisms by which we have data transfer from the EU and UK under a separate framework to the US for purposes of GDPR, essentially an adequacy decision, a limited adequacy decision. And the question is whether we have thoughts on the viability of that framework. I think that the viability of that framework, of course, is always in question if Max Schrems or others are bringing litigation against it. And I think many people expect that there will be challenges to it. And since we've already seen Privacy Shield and Safe Harbor before that be successfully challenged, it's quite possible that might happen here. So I do think most of my clients, rather than rely solely on the EU-US data privacy framework, are always having a backstop of standard contractual clauses or one of the other mechanisms, for data to be transferred from the EU or UK to the US. And then I think with respect to some of the other questions here, maybe we could take one more question and then I think we'll have to wrap up. And then there's a question here about the level of enforcement by states for the FTC against smaller life science companies for privacy and security issues. And I think Jen covered that nicely earlier, that we are seeing that the FTC is really concerned about, consumer directed when there's like a subscription service or some type of account consumers are making. I think when we're talking about a biotech company that maybe isn't collecting data directly from consumers, maybe you're just doing clinical trials because you're at the early stage of development and you're largely getting pseudonymized or coded data from clinical trial sites, a lot of those activities are going to fall outside the scope of the state laws because they're going to fall within one of the exceptions that Christine was talking about in those state laws for clinical trial activities, or they're going to be your pre-commercial company and you don't meet those thresholds of either revenue or data being collected that would cause you to be subject to the state laws. And from an FTC perspective, because they're so focused on consumer protection and clinical trials and research are regulated by other parts of the federal government like HHS through FDA and OHRP, I think FTC has less concern there. But definitely if you're engaged in any type of consumer directed activity, that could be within scope.
Thanks, David. I think just to take one last question, someone had asked, what's the strongest consumer privacy protections that we're seeing for healthcare data? I don't think you hit on that one. I will say there's a mix of many, many laws that have additional protections for sensitive healthcare information, but then the Washington My Health, My Data Act, I think is probably the law that goes farthest in terms of safeguarding and providing additional protections around health data, including putting a requirement for there to be sort of affirmative consent to collection of health data in the first instance, which can be actually a very problematic requirement or a tricky requirement to meet, depending on the context in which a company actually even receives that data in the first instance. So I would call out Washington as a particularly sticky law. Jen, any you want to highlight?
No, I think Washington, I think Colorado has some recent, I don't know if I would say it's the, strongest consumer privacy protections, but I think Colorado also has come out with sort of similar consent requirements to Washington and seems to be following in that vein.
And I would just note that I think if you are processing any like particularly sensitive categories of health data, let's say genomic data, there are additional state laws that are targeted just to those data categories, and you'll want to be mindful of those with respect to any secondary uses you're making or requirements for consent for collection of those data.
I think we had maybe just one more question around some of the enforcement actions and whether or not those have included de-identified data in bulk or whether they're really focused on individual level information. And the enforcement actions generally do not focus on de-identified data and bulk de-identified data. So those uses of data and potential disclosures of data are really not part of the focus of what the FTC in particular had been looking at, nor is it really a focus, I would say, for the states or for OCR.
I think with that, we will wrap it up. Thank you all for joining. We really appreciate it, and feel free to reach out with any questions.
Thank you to Ropes and Gray and to everyone that joined us today. Please visit our website at community.hlth.com to catch up on all Health Go Live webinars. And join us in Nashville, February 16th through 19th for Vive 2025.